An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know by Randy Barnett and Josh Blackman.
Affirmative action on the Roberts Court. Fisher versus University of Texas 1, 2013, and Fisher versus University of Texas 2, 2016. In Bakke, Justice Powell found that affirmative action could be a constitutional means to promote educational diversity on campus. 25 years later, in Grutter, the court upheld the University of Michigan Law School's holistic admissions policy, which considered race as a plus factor. Recall that Justice O'Connor cast a deciding vote in Grutter, 2003. Chief Justice Rehnquist was in dissent. Soon, the composition of the court would change. In 2005, Justice O'Connor announced her retirement. She will be replaced by Justice Alito. Additionally, Chief Justice Rehnquist passed away. He will be replaced by Chief Justice Roberts. In 2009, Justice Sotomayor replaced Justice Souter. The following year, Justice Kagan replaced Justice Stevens. The newly formed Roberts Court would revisit the issue of affirmative action in higher education in two cases, Fisher 1 in 2013 and Fisher 2 in 2016. Following Grutter, the University of Texas at Austin adopted a race-conscious admission policy. Justice Kennedy would observe that, quote,
the university considers race as one of the various factors in its undergraduate admissions process.
Abigail Fisher,
who's a Caucasian, sued the university after her application was rejected, and she contends the university's use of race in the admission process violated the Equal Protection Clause of the 14th Amendment.
Whether you're a male or female or white or black, it shouldn't matter. It should come down to, your grades and your activities and whether or not you deserve to get in, and it should be based on merit.
The lower courts ruled against Fisher. The Fifth Circuit Court of Appeals deferred to the university, both in the definition of the compelling interest in diversity's benefits and in deciding whether a specific plan was narrowly tailored to achieve its stated goals. Therefore, it upheld the admissions policy. Fisher appealed her case to the Supreme Court. The Supreme Court ruled for Fisher by a 7-1 vote. Justice Kagan had recused. Because Abigail Fisher would return to the court, this case is called Fisher 1. Justice Kennedy, who dissented in Grutter, wrote the majority opinion. He concluded that the Fifth Circuit's deferential approach was inconsistent with strict scrutiny.
Once the university has established that its goal of diversity is consistent with strict scrutiny, there still must be a further judicial determination that the means chosen by the university to attain diversity are narrowly tailored to that goal. And on this point, the university receives no deference.
Justice Kennedy explained that the university has the burden to demonstrate
that each applicant is evaluated as an individual, and not in a way that makes an applicant's race or ethnicity the defining feature of his or her application.
Moreover, the court observed,
narrow tailoring also requires that the reviewing court verify that it's necessary for a university to use race to achieve the educational benefits of diversity, and this involves a careful judicial inquiry into whether a university could achieve sufficient diversity without using racial classifications.
However, the court stopped short of declaring the university's policy unconstitutional. Instead, the court remanded the case back so the Fifth Circuit could apply the proper standard of strict scrutiny. 10 years earlier, Justice Thomas dissented in Grutter. He contended that there was no differences between racial classifications designed to hurt racial minorities and, quote, benign racial classifications that are intended to help minorities. In contrast, progressive justices contend that only, quote, invidious or harmful uses of race are prohibited. For example, in Adirondack Constructors versus Pena, 1995, Justice Stevens wrote that there was a difference between a no trespassing sign and a welcome mat. Justice Thomas vehemently disagreed with this approach. He quoted Frederick Douglass, the great abolitionist, quote, "What I ask for the Negro is not benevolence, not pity, not sympathy, but simply justice. The American people have always been anxious to know what they shall do with us. I have had but one answer from the beginning: do nothing with us." Justice Thomas explained, "Like Douglas, I believe blacks can achieve in every avenue of American life without the meddling of university administrators." He wrote that the Constitution abhors classifications based on race because every time the government places citizens on racial registers, it makes race relevant to the provision of burdens or benefits. It demeans us all. 10 years later, in Fisher 1, Justice Thomas stated that Grutter should be overruled. He explained that affirmative action did not pursue a compelling interest. Quote, "There is nothing pressing or necessary about obtaining whatever educational benefits may flow from racial diversity." Justice Thomas concluded that the University of Texas's arguments that educational benefits justify racial discrimination were no different from the arguments advanced in support of racial segregation in Brown versus Board of Education. In June 2013, Fisher 1 was remanded to the Fifth Circuit Court of Appeals. Notwithstanding Justice Kennedy's admonition, the lower courts failed to properly apply strict scrutiny. Once again, the same three-judge panel upheld the University of Texas's affirmative action policy. And, once again, the Supreme Court granted review. Fisher 2 was argued on December 9, 2015, before 8 justices. Justice Kagan was once again recused. Justice Scalia seemed like a solid vote to rule against the University of Texas. Likewise, Chief Justice Roberts, along with Justices Thomas and Alito, have consistently voted against affirmative action programs. Justices Ginsburg, Breyer, and Sotomayor seem to support the university's policy. That breakdown left Justice Kennedy in his usual position as the deciding vote. But with only 8 justices, at best, Justice Kennedy's fourth vote for the liberal wing could yield a 4-4 tie. And a 4-4 tie would have the effect of affirming the lower court ruling, without setting any precedent. 2 months after the case was argued, and the majority opinion was assigned, Justice Scalia suddenly passed away. His death almost certainly changed the outcome of Fisher 2. Instead of a 4-4 tie with no presidential value, the court upheld the University of Texas's policy by a 4-3 vote. Justice Kennedy wrote the majority opinion, joined by Justices Ginsburg, Breyer, and Sotomayor. He concluded,
"The record here reveals that the university articulated concrete and precise goals with respect to its admissions decisions."
These goals, the court found, were sufficient to satisfy strict scrutiny. Study guide. Did anything in the record change between Fisher 1 and Fisher 2? Justice Thomas dissented and repeated his call from Fisher 1 to overrule Grutter. He wrote the majority opinion, quote, "is irreconcilable with strict scrutiny, rests on pernicious assumptions about race, and departs from many of our precedents." Justice Alito wrote a separate dissent, joined by Chief Justice Roberts and Justice Thomas. He began, quote, "Something strange has happened since our prior decision in this case." He explained that following the remand in Fisher 1, quote, "the university has still not identified with any degree of specificity the interest that its use of race and ethnicity is supposed to serve. Yet, the court in Fisher 2
effectively defers to the judgment of the University of Texas that its plan is necessary to achieve a vaguely defined objective, the educational benefits of diversity."
He added, quote,
Such deference is inconsistent with Fisher 1 and with the very idea of strict scrutiny.
He concluded that Justice Kennedy's opinion for 4 justices is
Simply wrong.
Justice Alito obliquely referred to the fact that Justice Scalia's passing may have resulted in the court's changed direction.
I hope this is a one-off attributable to unique circumstances.
Study guide. What is the precedential weight of a 4-3 decision by the Supreme Court?